Good morning, everyone. This is the time set for oral argument in Luders versus Kingston, our cause number 1CA CV 21-0191. Counsel, I appreciate your appearing virtually for these oral arguments. As you'll note, there is no clock on the screen. I will be keeping time myself, but I ask each of you to monitor your own time. Each side has 20 minutes, but appellant has the right to reserve as much time as you'd like for rebuttal, responsible, of course, for watching your own clock. Should anyone exceed their 20 minutes, I will remind you. And if with that, we may begin. Thank you.
Thank you, Your Honor. Daniel Fredenberg on behalf of the appellant's defendants. Present with me is Lance Kingston, trustee of the trust. I want to stress at the outset of my presentation, Judge, I'm going to reserve 5 minutes for a rebuttal, but the key fact, I believe, is the genesis of the relationship between the parties here began with a lease agreement dated January of 2011. That lease agreement spelled out the terms wherein the Luders were to make monthly payments. Now, that lease agreement had the ability to convert into a purchase, an option to purchase.
This is the agreement that was never signed, right?
That is correct, Judge. You beat me to that.
So why are we calling it an agreement?
Well, we're calling it the relationship of the parties. So what we had was a month-to-month lease agreement or rent, wherein the amount was reduced to $1,400 per month. There was a period of time at which the Luders stopped making payments, specifically 27 of them. And at that time, then the trust listed the property for sale and this litigation ensued. The point of all of this, Judge.
Counsel, let me ask you a question. After you entered into this agreement, in air quotes, well, first of all, who was party to the deal that is presumably or arguably creating the equitable mortgage?
Well, it was the owner of the property, the Kingston Trust, and then the tenants, the Luders.
Is that okay? So if you look at equitable mortgage doctrine, we first have to identify a transaction, don't we? And that you have essentially what appears to be an absolute sale, but that is actually a security instrument to hide it, right? So what was that sale?
The sale, but wherein the trust acquired the property.
Okay. What I want to do is focus you. Aren't we looking at the sale of the property from Nichols to Kingston? And then that's what would go through whatever factors there are in the test, or even enter the equitable mortgage world. Isn't that the trend? I mean, you both seem to argue that in your briefs. I mean, this will sort of highlight, this how the Luders are involved, but the transaction again.
So the transaction between Nichols and the trust was that the trust paid cash and removed all obligations. Now, then it became a relationship of lessor-lessee with the Luders.
Okay. So at that time, did the Luders owe any or have any subsisting obligation? Did they have an indebtedness to your client that they had to? There was a creditor-lender relationship, lender-borrower.
No.
Okay. Is that significant?
It's dispositive.
Why?
It's dispositive because we have a situation where the trust is the fee owner of the property. It can't simultaneously have a fee ownership interest in a property and also a collateralized security instrument. It's a merger of title. They couldn't, because they owned it, because the trust owned the property free and clear, and because the Luders had no debt obligation, there was no interest for the Kingston Trust to secure. So the very fact that basically the Kingston Trust did not supply purchase money or loan funds for the Luders to buy the property, which is where the equitable mortgage doctrine is applied, where basically you've got a lender-borrower relationship. Lender gives money to borrower, usually in a distressed situation. However, lender does not want to document that with a deed of trust because
isn't there usually, I mean, who in this 7-part test, we use the words grantor and grantee.
correct.
Who are those people here?
The only grantee here was the Kingston Trust.
And who was the grantor?
Nichols.
Okay. So keep going.
So the Luders were never supplied purchase monies wherein they could take.
The Luders are neither the grantor or the grantee, correct?
That's exactly right. They're a tenant and never became more than a tenant.
So why are we talking about equitable mortgage when they weren't the grantor or the grantee?
That is precisely the question that I posited to the trial court.
Keep going.
I want to focus on the equitable nature and consideration of this arrangement. As the trial court was sitting in equity, it shouldn't be lost on this court that the Luders have not made a payment since 2008, 2019 on this property. They had the opportunity to purchase it back in 2012. They declined that. They became month-to-month tenants. And since then, Judge, they've been either occupying the house or subletting the property and pocketing the rent. So my client, the trust, has gone three years without a single payment, whether it be a lease payment or a payment on the judgment that's been entered by the court. But setting aside the morass of the 6 factors under the Shelton test, because
Let me ask you something else, counsel.
yes.
What else is there? Is there anything else in this case other than this legal issue? Like if we were to remand, are there other claims out there that you have asserted that need to be resolved still, or the other side asserted?
Yeah, we're appealing from a 54B judgment. There are other claims that are at the trial court level.
Tell me about your stipulation, this novel stipulation. What you seem to have a disagreement as to what it meant to file competing motions for summary judgment based on disputed facts. What were you trying to accomplish?
Rather than have cross motions for summary judgment, we were trying to simultaneously brief a summary judgment adjudication on a compressed time frame, frankly, as economy to the litigants.
So I guess fewer briefs, responsive and otherwise. Is it that's the economy?
That's correct.
Okay, because it's written, I think it uses the verb resolve or something like that, the court to resolve all claims. And it doesn't say anything about within the confines of summary judgment. Now, yes, everyone filed summary judgment motions and the court entered summary judgment. But why weren't you clear on that in the stipulation?
Well, in retrospect, we could have been clearer in the stipulation. The intention certainly was not to be in the Court of Appeals arguing about the standard of review. But I will say that this was really a dialogue with the trial court judge and counsel trying to come up with a creative way to expeditiously resolve this case on a summary judgment standard. And that's what the court ultimately entered, was summary judgment on equitable mortgage.
So we're supposed to ask if there's a genuine issue and send it back for what?
Well, we think that the trial court should be reversed on the grounds that we spoke about, the absence of the factors, the absence of the debtor creditor relationship as between the Luders and the Kingston Trust. But also, Judge, there's the statute of limitations that I think is a very clean argument, and there's not a factual dispute there. So we're asking the court to reverse and dismiss the equitable mortgage claim, or at a minimum, remand for factual findings.
For fact, you mean for trial?
For trial, correct. If any other members of the panel don't have any question, I'm going to stop now and reserve 7 minutes for rebuttal.
Very well, thank you.
Thank you.
And for the appellee.
Thank you. May it please the court. A couple of things. First, I want to talk quickly about the standard review and this novel mechanism. It clearly was an efficiency mechanism that the parties came up with. I don't think there were fewer briefs. Everybody fully briefed their position. But what was clear in the stipulation and in the court's order is that this was not summary judgment. This was submission to the court to weigh the evidence, not to determine whether there was a material fact that needed to go to trial, but to weigh the evidence that the parties submitted. There had already been 2 hearings. Parties and witnesses had taken the oath and presented.
2 hearings? I thought there was just the evidentiary hearing at the preliminary injunction stage. Am I missing another hearing?
I'm sorry. Yes, Your Honor. There were 2 hearings. I believe I submitted both transcripts as appendices to my brief. One was, I think it was February. It was a TRO hearing. The second one was the more expansive preliminary injunction hearing. But there were 2 hearings.
Okay, let's distinguish between evidentiary hearings and other hearings. Are these were both evidentiary hearings?
Your Honor, I believe the second one was the only evidentiary hearing.
Okay.
I have not reviewed the transcript.
Let's not detain ourselves too long on procedure. It seems to me that your clients are strangers to a transaction that they had the opportunity to participate in by signing documents and making payments, neither of which they did. and now they want to unwind a transaction between two unrelated parties. How does that work?
They're not strangers, Your Honor. It is an interesting approach, I think, to look at the actual transaction between Nickel and Kingston. But Nickel was kind of an intermediary. The Luders have owned this home since the beginning. They needed help. They've always been distressed. They had.
Let me stop you there, because I've heard you say that before. Let's just pick one moment out in time, and that is a foreclosure and a trustee's sale at which A&S acquires. Is your position, and please point me to the authority, that your client continued to have some interest in that home after it was foreclosed on?
I don't have authority for that. My position is the equities are yes. They had a hard money lender who had stopped making payments because he wanted to take advantage of the situation. And
so when you get a trustee's deed, I mean, Title 33 is pretty clear that a trustee's deed is the end of the road. And when that trustee's deed was conveyed, you're claiming without authority that we should ignore the statutes defining a trustee's deed?
No, Your Honor. I'm saying we should look at the situation. Nickel came in and said to Luders, I'm going to protect this home for you.
And that sounds to me like you're asking us to ignore it.
I'm sorry, I missed that.
That sounds, what you just said in response to Judge Swan's question is exactly what he asked you. Should we ignore it? And you say no, but then you give us an explanation on why we should ignore it.
I apologize, and that's fair. So, I mean, I am not suggesting, obviously, that we ignore the statute, but I am suggesting, and maybe this is exactly what I shouldn't be doing, that we look at the facts, that we look at what happened here.
That argument was made, I've been on this court since 2008, throughout the Great Recession, and that argument was made in countless show me the note cases. People claiming they were in distress, that they lost their home, but they really, the lender was somehow at fault, but they didn't make the payments. And those cases culminating in BT Capital make abundantly clear that the trustee's deed is the end of the road. How do you get around BT Capital?
Well, I have not addressed that. I don't believe that has been at issue here, which maybe goes back to my process argument. The court looked at this, and this should not be a de novo review. The court has looked at the equities and made a decision that really the whole transaction here, Kingston got into this knowing.
But what's the authority? I'm sorry, but what's the authority for the court to look at any equities when there's a trustee's deed? Trustees' deeds aren't about fairness, and the statute that defines trustees' deeds and the deed itself are conclusive. And how can we, consistent with the law, start looking at equities and facts and who's distressed? That doesn't seem to be allowed as a matter of property law. Now, I suppose you could argue that somehow your clients were defrauded and bring a tort action for money damages, but that does not equate to a cloud on title.
Counsel, let me ask you.
No. I'd like an answer to my question first.
I'm sorry, Your Honor. I missed the question. I understood what you were saying. I missed the question.
I'm asking how you, given those principles that I articulated, how you maintain that we have any authority at all, or that the Superior Court had any authority at all, to look at facts and equities.
I'm not sure I come prepared to address that specifically. We argued equitable mortgage. Your Honors have seen that, and that's where this road has taken us. There's been no argument that the argument has been, did the factual situation define or indicate an equitable mortgage, or did it indicate that it was a tenant and landlord situation? That is what we've done. I'm afraid I have not come prepared to address what is a threshold
Okay.
question that has not been raised.
Then I believe Judge Weinzweig has a question for you.
This is out there. Be able to tell the kid.
Let's talk equitable mortgages. All right. So would you agree with me that a lender borrower relationship is a prerequisite before you can even get into those 7 Merriweather steps to have an equitable mortgage?
Yes, Your Honor.
Okay. And then who is the borrower and who is the lender here?
The Luders borrowed the $135,000 from Kingston that became the Kingston Trust.
Okay. They borrowed it. I think the record shows it was both negotiated between Nichols and Kingston, and the money paid directly from Kingston to Nichols. Where are the loan documents? I'm not even sure if that fits in, but where are the loan documents that show that relationship here?
Well, the loan documents, I mean, it was an unsophisticated and frankly an old way of documenting this kind of transaction. Those documents are the purchase and sale agreement, the right to redeem. Your Honor is correct. The payment was directly from Kingston to Nichols, but it was negotiated by Luders. Luders spent the $10,000 on a headhunter to find a hard money lender to take Nichols' position as the lender.
Right. So again, I'm looking at the evidentiary hearing, and Nichols, and Kingston, they say they negotiated it, and so let's move then to the 7 elements, and we use the words in Merriweather grantor grantee. Is that right?
Correct, Your Honor.
Right. Who's the grantor and who's the grantee in this case?
Well, in this case, it's the Luders who had through the
what are they granting?
Well, Nichols had taken the spot as the hard money lender that held title to the property.
There was a foreclosure before Nichols.
I'm sorry?
There was a foreclosure before Nichols. A&S purchased it and they sold it to him.
Yes. Well, okay. There was a foreclosure. It was now it's gone. It wasn't Goforth. It was the guy after Goforth.
Goforth and the guy who let it go. I don't understand why that's even relevant, but what's his name? Yeah, the second one who let it go into foreclosure, Stanley something. But keep going.
Well,
how does it get you?
Thurston is the name. I see the name here. It's Thurston. So Goforth and Thurston, right? Thurston wants to buy the home at auction. He gives it up, and Nichols steps in essentially to that. And
A&S. Okay, there was a trustee sale. Let's slow it down in 3 or 4 steps. Trustee sale. A&S acquires it. Within a week, sells to Nichols. Keep going. Is that free and clear?
Nichols, and yes, he buys it free and clear, calling Luders saying, hey, I want to help you out with this house. I am going to essentially recognize you as the owner. I have purchased it for you. That's what Nichols does.
Let me read you some testimony. This is Mr. Nichols speaking, not me. Question to Mr. Nichols at the evidentiary. So you were just doing it to help him out, even though he had no real legal claim to it? Question. Answer, that's true. Keep going. How does that possibly jive with what you're arguing here?
Well, I think that's everything, right? That the panel has pointed out the deed removes the interest. Luders don't have interest. Nichols knows Luders don't have an interest, but gives them one. And he steps in and says, I'm going to purchase this home. I'm sorry?
What interest other than an unwritten lease agreement and an unwritten option agreement?
That's the interest. That's where the equitable mortgage doctrine comes in.
which your clients refused to sign.
They made payments under it. I don't know
But
about
they
refusing to
didn't sign it. We have a statute of frauds in this state, and they didn't sign it.
Yeah, and this is even, Judge Swan, we're even talking about the predecessor to Kingston here. Kingston tried to get it in document, and they wouldn't sign. This is what preceded. So it's almost as if we're, the Luders are trying to pass this equitable mortgage thing, although it hits a wall at the foreclosure. But that it's an option. So you're telling me that an option is a sufficient interest in a home to obtain an equitable mortgage?
Yes, Your Honor. In this case, Nickel recognized the Luders' interest in this property. And
So if I have an option to purchase a house, let's say I'm renting a place in Phoenix and I have an option to purchase it, I have a claim against the owner for an equitable mortgage.
If the facts are like the facts in this case, Your Honor, yes, that's the whole point. The Luders exercised ownership. To address quickly the statute of frauds comment.
But no, usually in these cases, you have a grantor and a grantee. Here, that would be Nickel and Kingston. See, you keep trying to bundle these things together, don't you? I mean,
I'm sorry. Yes, Your Honor. I am absolutely bundling Nickel with Luders because they bundled it. That was the point. That's Nickel testifies to that. Yes, Luders did not have.
What about when Nichols explains to the court he never would have purchased the home if it had any clouded title or are there any title issues to it? Again, you're saying he came in, he learned his friend, he bought the house, he learned his friend had an interest, and he conveyed to him an option with a lease agreement, and that turned into the equity interest?
No, Your Honor. I think that the facts are switched just a little bit. Nickel only purchased it because it was his friend's home. He didn't purchase it. He was looking at it. This was something that he did. He was looking at it, but I believe what he testified was, I saw my friend's home was there, and I called him and said, what's going on? And because it was his friend's home, he bought it to help his friend. That's important. That chronology is important.
What enforceable interest did your client have at that point in time?
I don't believe at that point in time when Nickel purchased it, all at that point, the enforceable interest is, I mean, I'm not even sure there's reliance. I don't know that there is an enforceable interest. The enforceable interest.
So your client had no interest at that point in time during that transaction, even though there may have been a beneficial concept on why he purchased the home. Your client had no enforceable interest.
When Nickel purchased the home. So
when did they obtain an enforceable interest?
When they negotiated with Kingston to step into Nickel's place as a hard money lender and lend them $135,000 for the home. That's when they obtained the enforceable interest.
So now Nickel lent money to your client? Is that what you're saying?
No, I'm saying they treated that as a loan. The loan was when Kingston pays the $100. So Nickel only buys the home because it's Luders. He spends the $135,000 and he gets a little bit more back. And,
yeah,
and they treat that.
The record's certainly not clear on that at a summary judgment stage, but keep going.
Well,
we'll accept it. Keep going.
So Nickel has the property. He spent the money and he's telling Luders, I need to be paid back for this. I need to be paid back for this so you can get the home back. Luder says, I don't have the money. I'll go find somebody to step in the shoes. And that's the loan transaction. He gets the headhunter. He arranges it with Kingston. Kingston talks to Nickel. Nickel is certain, or he's at least satisfied that Kingston will protect this interest that Luders have in the home. And the loan is Kingston pays the $135. He pays Nickel off.
I thought you just told Judge McMurdy that there was no interest at the Nichols transaction stage.
This is when this interest arises. This is when Nickel purchases it, and correct, Luders don't have an enforceable interest at that point. But then at the purchase, I mean, there's no documentation, right? This is between the parties. And Nickel says to Luders, I need to be paid off for this. I bought this home so you can have it. I need to be paid off for it. That's what Luders goes and arranges. And Kingston steps into that transaction knowing that the whole idea is that this is Luders' home. And
so the only interest that Luders has is created by some inchoate benevolent intent that Nickel has to Luders, and Kingston's supposed to live with that?
Kingston's not supposed to live with it. He knew what he was getting into, and that's again,
the interest that you're identifying is just some benevolent, friendly intent by Nichols. I mean, it would be great if the world operated just on good vibes, but that's not what property interests are made of. Is there something here that created an legally enforceable interest?
I believe so, Your Honor. Yes, what happened is the Luders and Kingston create this transaction. They document it in the way they document it, and then the Luders start making the interest only.
But they didn't document anything because the Luders didn't sign the documents.
They didn't sign them, but they made payments on them. They performed under the documents, under the transaction, and Kingston recognized that.
I thought the option was only for 12 months.
That's correct. In the unsigned document,
they didn't exercise that option within that 12 months, did they? So even if there was some type of partial performance, they didn't have a viable enforceable interest after the 12-month expiration.
They continued to pay. It's what the parties did.
A month rent at that point in time, wouldn't it?
No, it wouldn't, because this is determinative. When Kingston has the son ready to purchase the home, if Kingston owned this and understood that he owned it, Kingston didn't need to call Luders and ask them, hey, should I sell this property? But twice, Kingston calls the Luders and says, it's your home. Do you want me to sell this to your son? And Luders says,
right, again,
no.
Seizing on the beneficence of another, or is that? You said he didn't need to call him, but he called him.
Right.
So beneficence.
Because he didn't, yes, it was beneficence. That's exactly what it was. The Luders caught a break with Nickel and Kingston, and will Luders get Kingston? I believe my 20 minutes is up. It is an interest that comes out of the beneficence of the parties, that now the son who inherits this looks at it and says, I want to make a profit of it. And he ignores everything that has happened.
And you're right, your 20 minutes is up, but if any panel member has any further questions. No? Okay. In that case, we'll return for a brief rebuttal. Counsel?
Thank you. So I want to talk about three critical steps of potential of either actual or inchoate interest. The first one, Judge Swan, you seized upon was the expiration and termination of the Luders' interest as a consequence of 33A11E, the trustee's deed operating as a complete foreclosure of the Luders' interest. Now we hear of a second interest, I'll call it a benevolent interest between Nichols and Luders. Whatever that interest is, and the record is not developed, and I don't think it's even in front of this court, but for the purpose of the logic of that argument, at such time as the Kingston Trust bought the property from Nichols, whatever interest the Luders then regained vis-a-vis this benevolent arrangement with Nichols expired. That's the second termination. The third inchoate interest that the Luders had was the lease option to purchase, which was in 2011. That was a 1-year option. Now, we raised statute of frauds. I believe that the trial court rejected, obviously, statute of frauds, but I believe it's Judge McAuliffe pointed out there was a 1-year that was a 1-year expiration. If I mispronounce your name, Judge, it's because I can't see. But in any event, those 3 data points, those 3 points in time, each point in the direction that the Luders never had any interest, or if they did, they expired. That defeats the standing requirement under equitable mortgage. That destroys any possible equitable mortgage analysis, because Kingston did not supply funds by which Luders acquired title interest in the property, which is the entire reason why equitable mortgage doctrine was designed. It was designed to prevent the situation where really a hard money lender would avoid usury laws by not having a deed of trust or a mortgage on the property. And so rather than reducing that to writing, that they would just not have a mortgage on the property. And that's why equitable mortgage developed and was designed to protect the borrowers where there was actually a debtor-creditor relationship. Where all this ends up, Your Honors, is that statute of limitations clearly defeats equitable mortgage claim, because at the latest, that equitable mortgage claim had to have been brought at the 12-month. It accrued at the expiration of the unsigned 2011 option agreement. Judge Swan, I saw you were about to pop in.
No, I was merely breathing. You're welcome to continue.
Okay. What I hear now, just to finalize my thoughts, is that actually, rather than an equitable mortgage under Shelton, what we really have is an equitable assignment, wherein the plaintiffs are attempting to enforce an equitable, benevolent assignment of the agreement between Nichols and the Luders that happened back in 2011. There obviously is no such doctrine as an equitable assignment of an equitable mortgage, which is really the best way I can characterize Mr. Anderson's argument. I don't have any further comments, Judge, except for a few facts which I'll highlight that weigh in favor of the fact that the Kingstons were the owner and the Luders never had an interest. It's undisputed that real estate taxes and insurance had always been paid by the Kingston Trust. These are all indicia of pure ownership, not of creditor-debtor relationship. If the Luders truly had and behaved like they owned the property and were the borrower, it was incumbent upon them to protect their property through payment of real estate taxes and insurance. So those are just some facts, I think, that might be parenthetical to the legal analysis, but I wanted to raise them at the end for the court. Thank you. I don't have anything further unless the court has some questions for me.
All right, thank you, counsel. The matter is now under advisement. The court will issue a written decision in due course, and we will stand in recess.
Thank you.
Thank you.